Every day in the USA, people find themselves in court.
We will go on the record in the matters 25 CF 54, 25 CF 53, State of Wisconsin versus Zachary Chafee and Laura Chamberlain. These are two separate matters, but they are we are combining the hearings together because they are co-defendants and for ease and efficiency. This is a motion for reconsideration off of the court's denial for suppression. I've reviewed and have in front of me both briefs as well as accompanying documents from the defendants, as well as the brief and accompanying document from the state. How would you like to proceed? Because I know what the state argued in the brief and indicated that testimony would be needed or believed that it would be needed. And if you believe it would be needed, then, and I heard something about testimony or question.
Judge, I was planning on calling my client.
Okay. All right. So that's how we will begin. I'm going to have both of the individuals, the defendants, please rise and raise your right hand and you'll be sworn in.
Do you swear that the testimony you're about to provide today in this matter is the truth, the whole truth, and nothing but the truth?
I do. You may be seated. Any objection from the state to have the defendants appear and be questioned at the table, or would you like them in the witness stand? Either way, it doesn't matter to the court.
I hope it's not much of a hassle, but ask for the witness stand just because I'm deaf in my left ear.
All right, that makes sense.
And Judge, I believe only Miss Chamberlain is going to be testifying.
Okay, great. Good to know. And for the record, we have Shirlene Perrin appearing in person. We have Zachary Chafee, her client, appearing. We have Laura in custody. We have Laura Chamberlain appearing in custody. Her counsel, Renee Tabor. We have the state appearing through District Attorney Kevin Schmidt. All right. Can you please bring her over here to the witness stand? She has already been sworn in. Ms. Tabor.
AKA Landgraf.
Oh,
just so the record.
Sorry. Oh my gosh. I don't know why I've done that the last couple days. We've been married for a long time.
4.5 years.
4.5 years. I apologize.
That's okay. There's other judges that do it too. You've been really good though until like 2 weeks ago.
Yes,
yeah.
I don't understand it. Okay, I apologize for that. Ms. Landgraf.
People are gonna start thinking I got divorced or something. I have problems. Okay. Ms. Chamberlain, you're the defendant here in 25 CF 53.
Yes.
And your co-defendant is Zachary Chafee.
Yes.
Just briefly, how do you know Mr. Chafee?
We met in December of 2019 and have known each other since. My ex-husband and I actually met him together.
And your ex-husband is Troy Chamberlain?
Yes.
The three of you met each other in 2019?
Yes.
What's your current relationship?
I am now divorced from Mr. Chamberlain and I am seeing Mr. Chafee.
So did your divorce action take place in Polk County, Wisconsin?
Yes.
And that was finalized in July of 2024?
Yes.
Okay. And there was a commercial building located at 101 West Madison in Grantsburg. Was that part of the property division in your divorce?
Yes.
And what did the court order initially regarding that property?
That the Grantsburg property would be mine and I needed to have my ex-husband removed from a loan.
So you were required to refinance that?
Yes.
And did that happen?
No, I was unable to refinance it.
Okay. So what happened because of that?
I was found in contempt of court and forced to give the property over to my ex-husband.
Was there a point where you were trying to sell
Yes,
the property? And when did that occur?
I had been working on selling the property from October until the day, March 15th, when it was awarded to my ex-husband.
October 2024?
Yes, sorry.
And your ex-husband, Mr. Chamberlain, was ordered to take possession of the property on March 16th?
Yes.
Prior to March 16th, what were you doing with the property?
We were living there, as well as had plans to close my bar, start a liquor store, and create apartments for other people to live in.
Okay, when you say we, do you mean you and Mr. Chafee?
Yes.
May I approach you with email? Carolyn, I think it's been marked as exhibit number 1. I recognize what that is.
Yes.
What is it?
It's the commercial and residential building that I was awarded in my divorce.
And that's from the 101 West Madison property in Grantsburg.
Yes, ma'am.
Judge, I would move to admit exhibit 1 as demonstrative evidence.
No objection.
Received.
Did you have a lease on the property?
Yes, Mr. Chafee had a lease.
Who were the parties on the lease?
Mr. Chafee and his business.
And you
And
as the,
yes, ma'am.
and this was at the time that you were awarded the property in your divorce?
One of the leases was dated for him to be able to utilize the space from May 1st, 2024. And then the residential lease was started November 1st of 2024. Or I believe November 1st, excuse me. I don't have it in front of me, so I don't.
Right, that's 2.
I'm handing you what's been marked as exhibits 2 and 3.
Thank you.
Do you recognize those documents?
Yes, I do.
What are they?
They're the leases for Mr. Chafee, between Mr. Chafee and I.
And for the record, which one is exhibit 2?
Exhibit 2 is the rental lease agreement,
And exhibit 3?
is the business space lease agreement.
Do you know if all the pages of the lease are there?
I believe they are not.
And do you believe that
I'm not sure. what
either one or
happened to
both of them is missing like a page or 2?
That's what I've been informed, yes.
Do you know what you've been informed? I handed you these
Yes.
leases earlier at the jail and you
Yep.
were able to look through
Yep.
them.
Yep. Okay. There are pages missing, sorry.
All right, I'm just gonna say, Ms. Chamberlain, please wait until Ms. Landgraf is done asking her question or making a statement, because when you talk over her, the court reporter has a very difficult time taking it down. Okay?
Yes, ma'am.
I handed you those lease agreements earlier when you were in the jail
Yes.
and you've had an opportunity to look through them.
Yes.
You handed them back to me right here in court.
Yes.
So you are aware that each one is missing a page or 2?
Yes.
Do you know where those pages are?
No,
Do you have any idea where they could be?
I don't know where they are. They could have been lost when I showed the paperwork to the deputy when we were removed from the property because they were thrown onto the ground.
Oh, let's back up. Okay, so at the last hearing, Deputy Krupa testified that she came to the apartment,
Yes.
correct? And that either you or Mr. Chafee handed her the leases?
Yes.
Are those the leases right there in exhibit 2 and 3?
Yes.
And what did she do with those?
She took them and threw them on the ground.
Okay, so you don't know if all the pages were collected when you picked them back up.
Correct.
Did you personally sign those leases?
Yes,
Did you personally observe Mr. Chafee sign them?
yes,
And you indicated that one lease was approximately 6 months earlier than the other lease.
yes.
Judge, I move to admit exhibits 2 and 3.
Mr. Smith,
No objection.
they are received. And for the record, they are attached to both your filings.
They are, Your Honor, but I believe that the signature pages for the rental lease and for the business lease are swapped. I think the DA pointed that out in his brief that the signature pages were switched with like the one that started in May was on the other one.
I noticed it was different or weird, but I still found 2 signature pages.
Yes, they were just out of
Okay, thank you.
order. Now on March 15th, why didn't you call Troy Chamberlain and let him know that the sale wasn't going through?
Because I was still talking to the buyer up until March 15th. We were trying to get a resolution to paying off the loan.
So up until the last hour, you were actively working on getting the building sold.
Yes, ma'am.
And what was the plan with the building when you were selling it?
The plan was that I would sell it and that I would be buying it back.
And that the leases would continue with whoever was purchasing the property?
Yes,
And did Mr. Chamberlain know about the leases?
yes.
How was he aware?
Mr. Chafee testified in court in Polk County for my last divorce hearing, stating that he did have a lease or had leases.
And that was on February 3rd.
Yes,
And I believe I had showed you the transcripts that the DA filed yesterday. Is that the hearing that you are referring to?
yes,
For the record, the court did take judicial notice of Polk County case number 23 FA 112. For the record, I have reviewed that entire transcript.
Thank you. And did you attempt to contact the Polk County Court regarding the lease issue that you had?
yes, after I was removed from the property.
Always the one that's filed after the fact. Yeah, I see that.
Okay, you with mark as exhibit 4?
Yep.
You recognize that document?
Yes, I do.
What is it?
It's a response from the February 3rd hearing dated March 31st, saying that Polk County, that Judge Anderson said that I was asking to enforce the rights of Mr. Chafee in the divorce case. He has no party in this case. The court does not have jurisdiction in this case over Mr. Chafee. Ms. Chamberlain makes reference to rights Mr. Chafee might have as a renter. Oops, I'm sorry. This court does not have jurisdiction in this case over Mr. Chafee.
Based on that document, it was your understanding that any lease issues needed to go through Burnett County.
Yes, that's correct.
Your Honor, I'd move to admit exhibit 4.
Mr. Schmidt,
No objection.
received.
No further questions, Your Honor.
Ms. Perrin, do you have questions for Ms. Chamberlain?
I do not.
All right, Mr. Schmidt.
You made reference to the building of a plan to sell the building but buy it back. Could you elaborate more on what you meant by that?
Yes, I was working with an investor. I was going to sell the building to them and then buy it back from them.
Did you tell Judge Anderson in the family court case at the February 3rd hearing you were going to buy it back from that person?
I don't recall.
You think that would have been important for him to know?
I felt that because it had been awarded to me and I was allowed to do what I needed to refinance this loan that we had, and the divorce was final, that it was not my ex-husband's business to know if I was going to keep the building or not.
Did you believe it was the family court's business to know?
Sustained. It opens a whole nother can of worms in another count.
Were you living with Zachary Chafee in the space you were renting to him?
I was staying with him.
Were you living with Zachary Chafee in the space you were renting to him?
I lived in that building, yes.
But in his rented space or in a separate space in the building?
I was in between a different space and the rented space.
So sometimes, but not all the times,
Correct.
because you are the general owner of the whole building, but also dating one of the tenants.
Correct.
Okay. The spaces that Zachary Chafee were renting were the middle floor with the workshop,
Part of the middle floor.
part of the middle floor, but or the part with the workshop,
There was a workshop, yes.
and he was renting a segment of the basement as well,
The entire basement.
the entire basement. So you've been present in both of those, not as a landlord, but as seeing Mr. Chafee.
Yes.
Was Zachary Chafee paying you the full amount of the rent every single month?
Not-
Objection relevant, I don't.
State is arguing it's a sham lease. I think it's relevant.
That was in his brief. That was exactly an argument he made in his brief, that he believes that this is, as he says now, sham. I thought he said a fraud or something of that nature. I'll allow it a little. We'll give you a little leeway with that.
Mr. Chafee did pay me. He paid me with work done to the building. He gave me items, building materials, so that once everything was all finalized, we could work on changing the floor plan. And also antiques that we were planning to sell after everything got done.
Are you saying he didn't pay you in cash, but he gave you services or items that you thought of equivalent value?
Correct.
Was he involved in your plans with selling the building, including finding the person to sell them to?
No,
No. Why did you have him come and testify about those things at the February contempt hearing then?
so that my ex-husband would know that I was working on getting that loan refinanced.
But why was Zachary Chafee involved in you getting the loan refinanced?
He wasn't.
Okay. You said that the building was awarded to you previously. What exactly do you mean by that?
As part of the divorce, the building was awarded to me.
Were you ordered to have Mr. Chamberlain sign a quitclaim deed?
Yes,
And he did that,
yes.
but you never filed it with the register and probate.
No, I did not.
So his name was still on the deed.
Yes, but I had the quitclaim deed. I don't have it any longer, but I had the quitclaim deed that was signed.
And wasn't the issue at the February contempt hearing the fact that with his name still on the quitclaim deed, he was getting in trouble for you not paying the taxes?
I don't know.
You don't remember what happened at the February 3rd hearing?
I don't remember exactly.
And wasn't one of the other issues his name being on the loan, as you did talk about the loan today, if you didn't make payments and his name's on it, he's also in trouble for that.
Yes,
So the reason why Judge Anderson at the February contempt hearing ordered the property to just, if it's not sold by March, was because Troy Chamberlain was suffering injury because his name was still on all this stuff.
yes.
Okay. No other questions?
Ms. Landgraf? Any additional direct?
Ms. Chamberlain, did Mr. Chafee work on that building, when you and Troy Chamberlain were still married?
Yes, Troy Chamberlain hired him in April of 2023 to do work on the building for us.
Okay, so he's very familiar with Zach and what he was doing with the building.
Yes.
No further questions.
Okay, Ms. Perrin?
After you were, excuse me, after you were awarded the property in the divorce, did you have any other tenants besides Mr. Chafee?
Yes,
Okay, and how many?
2.
No further questions.
Mr. Schmidt?
What parts of the buildings were these other people leasing residing in?
One was the second floor space, and the other was a room in the basement.
Were there periods of times where these other leases were going at the same time as Zachary Chafee's lease?
Yes,
Where were you residing during those times? Was there still a space that was exclusively yours?
yes.
Where was that?
It was in one of the main floor rooms.
Okay. No other questions?
You said the main floor rooms?
Yeah.
Ms. Landgraf?
Nothing further.
Ms. Perrin?
Nothing further.
All right, thank you. She may step down. Ms. Landgraf, additional witnesses?
No.
Ms. Perrin, any witnesses?
No.
Mr. Schmidt, any witnesses?
No witnesses. I would move to enter the segments of the transcript I attached in my brief as evidence. It sounds like the court's just taking judicial notice of the whole transcript, though.
I have, and I've done so already.
So I'd ask the court to do that instead then.
All right, I've taken judicial notice of the entire Polk County family matter at the last hearing, at the suppression hearing that we had, I believe. Well, I think my order was December 8th, but I can't remember when our hearing exactly was. I did take judicial notice of 23 FA 112, the Polk County matter. So I will do so on the record with regards to that entire transcript. Argument, Ms. Landgraf?
Judge, given the evidence, although I don't think that it was specifically necessary that we needed to enter the lease into evidence because Wisconsin statute 704.19 periodic tenant would apply. But clearly these leases were signed way in advance of any contempt hearing. There was a plan for the building. And Mr. Chafee had a reasonable expectation of privacy, and my client was his overnight guest. And I believe that all of the evidence should be suppressed.
Ms. Perrin?
Just to address a couple of issues, maybe a little bit out of order. The fact that Ms. Chamberlain had other tenants goes to the credibility of her statements about this lease. The fact that there was testimony about this lease before the officer approached the house on, I believe it was March 16th, telling Mr. Chafee he had to leave, reinforces the credibility related to the lease being in place before. I would agree that a periodic tenancy would have been in place otherwise. However, there are certain factors that I just stated that go to the issue as to whether there was a lease or not. The officer, and I put this in my original brief, her decision to throw the lease on the ground and claim ignorance was not done in good faith. And that does not absolve the police of violating constitutional rights. And so, again, we renew our request to suppress the evidence. Thank you.
All right, Mr. Schmidt.
We have a number of different issues within the same motion that all interestingly have different viewpoints. That is, they have different standards of review. When we talk about whether the defendants met their burden of showing there's a legitimate expectation of privacy in an area, we're taking an objective standard, we're taking a look at all the facts, we're actually determining, did this person have legitimate legal rights? You look at Seventh Circuit case law, they do get into the morass of, is the person illegally staying there? Do they have a valid lease? Things of that nature. I think the court made a decision on its order for that. All of the evidence entered today goes towards that one. The court also, in its decision and order, made rulings that suppression wasn't merited for other reasons. None of those reasons have been touched on today. To those other two issues, I direct the court. The first law enforcement contact with Karen Krupa, her coming there with Troy Chamberlain to remove Laura Chamberlain to enforce the order as she read it from Polk County, which does clearly state law enforcement must go there and help remove Laura Chamberlain. She's not to be there. No leeway to be there as an overnight guest of somebody who does take possession of the property. I don't even think Troy Chamberlain could have gave her permission to stay there with that court order. They enforce that order. They don't need to take all arguments other people give them to the otherwise. If they had chosen, I'm not going to remove Laura Chamberlain, I'm not going to remove Zachary Chafee, I'm not going to let Troy Chamberlain take possession of the building as the order says, they were running awry of the court. And Karen Krupa was correct when looking at both things to say, I've got to follow the court order. You should litigate your claims in the Polk County Court. Because Karen Krupa saw no piece of criminal evidence there, because the only way she saw any was after Troy Chamberlain was there, he called her and said, hey, we found a marijuana plant. Her observations of what she did there are completely severed from the warrant that would happen later. None of those observations went into the warrant that happened later. It's disconnected, and if the court found that there were a constitutional rights violation, that eviction is the sole grounds of removing Zachary Chafee, the remedy would not be suppression of evidence. The remedy would be a civil suit. Just the same way that if a no-knock is violated, the violation, a no-knock, sorry, I'm underwater. Just as if the constitutional prohibition against unreasonable no-knock search warrants implicit in the Fourth Amendment was violated, the remedy is not to suppress evidence. The remedy is to allow them a cause of suit. The remedy must be tied to the violation. The police were not searching for evidence. They didn't even find evidence. The police were enforcing an order. The remedy doesn't make sense. What the court would have to find to suppress evidence is it'd have to find either the warrant that they executed was so plainly deficient no reasonable officer would rely upon it, or that there should be evidence suppressed off of what Bridget Getz did, somebody who had nothing to do with removing these two individuals from the building, and that as a result of her observations being unconstitutional and then being removed from the search warrant, it no longer met probable cause. As I've said in my previous motion, I don't think that applies. I think that's what the decision order concluded to. Thank you.
Thank you.
I respond.
Did I ask Ms. Landgraf for argument?
I went first.
Oh, sorry. Yes, I will ask Ms. Landgraf if she has a response.
Miss Karen can go first. That's fine.
Ms. Karen?
I just want to refer to the brief I filed on November 10th, again, citing a decision by the Supreme Court, reiterating its position that a seizure of property occurs within the meaning of Fourth Amendment whenever there's a meaningful interference with an individual's possessory interest in that property. When it comes to my client, he was not part of the Polk County order. He was not noticed in any way. He was not named on the order. So his privacy rights, it was clear that he lived there. He was giving the officer, trying to tell her that he had a lease, obviously stating that he lived there. That's what she testified to. And that gives him a privacy interest. And so his interests were interfered with. And as such, the resulting evidence that was found because of that interference with his possessory interest
You can't talk to each other.
should be suppressed.
Sorry, Ms. Perrin. The defendants were talking to each other. So I missed the last
I
brief
just
statement.
said that because of the interference with his possessory interest, the evidence that happened after that should be suppressed because it all stems from that one event. And because he's not part of the Polk County order, he wasn't noticed on that. He's not part of that paperwork. His privacy interests were interfered with.
Thank you, Ms. Perrin. Ms. Landgraf?
Well, I would agree. The only reason why the officers went in there beforehand was because, or the only reason that the security guard or whoever even had access is because the police involved themselves in the first place when they shouldn't have. So I think everything stems from that, the fruit of the poisonous tree.
Okay, thank you. I'm not going to make a decision. I'm doing a written decision. Because quite honestly, I do think that, as Mr. Schmidt stated, I don't know how he exactly stated, but there's multiple issues that have multiple levels of review. And I believe that to be true. And I want to make sure that I review them and I reconsider my previous decision, perhaps in total. Now that I have leases and some information as it relates to that, instead of just having the officer testimony from Deputy Krupa. So I will get that out as quickly as I practically can, knowing that we do have, I believe it's a February 6th final pretrial, and then I think a March 3rd jury trial start date. So I want to get that out as quickly as I practically can, and so I will work on that diligently.
Thank you.
All right, we are adjourned. No.